following is a local resident producer's program. The program content is the sole responsibility of the producer and does not necessarily reflect the views or policies of CATV2, Oshkosh Community Media Services, the City of Oshkosh, or Time Warner Cable.
The People's Law School is a program produced by the Wisconsin Association for Justice. The Wisconsin Association for Justice, WAJ, is an organization comprised of over 900 consumer advocate attorneys across Wisconsin. WAJ's primary function is to protect the rights of injured Wisconsin consumers and to preserve the civil justice system, including the right to a jury trial. WAJ champions the cause of those who deserve justice for injury to person, property, or civil rights. WAJ also promotes the public good through efforts to secure safer products, a safer workplace, a cleaner environment, and quality health care. WAJ works to educate the public on the importance of the civil justice system. As part of its educational program, WAJ produced the People's Law School, designed to remind the public about its legal rights and our legal system. This program is about how a jury trial works. Thank you for joining us to learn about Wisconsin's legal system. I'm George Curtis. Welcome to the People's Law School, brought to you by the Wisconsin Association for Justice. We're going to talk to you about your legal system, how it works, how it's supposed to work, and how you may want it to work better. We have guests that are very knowledgeable because they practice in this system. They're Wisconsin trial attorneys, for the most part representing injured people in court cases, usually against insurance companies. Our first guest is Chris Stombaugh. Welcome to the show.
Thank you, George.
You're a litigator. Tell us a little bit about your litigation experience.
Well, I've been practicing nearly 20 years now, for the most part representing individuals in cases against corporations, insurance companies, and sometimes dairy farmers against utilities in stray voltage cases.
You largely deal in the presence of a jury, and a jury is the decision maker. Why is that important in our system?
Well, it's important because it's what our founders deemed to be the best way to solve disputes. The Seventh Amendment to the Constitution and the Wisconsin Constitution also supports the idea that disputes should be decided by a jury of our peers, just like in a criminal case.
That isn't true in most countries, is it? In most countries, somebody other than your peers gets to decide your futures, somebody a lot more closely tied to the government, and somebody who can easily be bribed.
That is unfortunately true, and we've seen that in the justice systems of Europe in the past, but in South and Central America, where a judge is the judge and the jury, deciding every issue in a case.
In this country, we empower the people, the common citizens, both with the ballot box and with the jury box. How important is that to fair and impartial justice?
It is absolutely important because the jury is the one part of our government that can't be influenced by money.
How good a job do juries do?
Juries, for the most part, do a fantastic job. And that has a lot to do with the selection process. I mean, people are selected at random through the community. They're brought in. They are questioned by the judge and by both sides. And then a selection process is made to get really the best jury for that case.
What are the qualifications to be a juror in the state of Wisconsin, for example?
Well, it is essentially the same ones which we have to vote. You have to be 18. You have to be a citizen, both of the state and of the jurisdiction, the county in this case, where you would be a juror.
Now, can jurors hear the evidence and vote and be immune from prosecution or from any inquiry as to how they arrived at their vote?
Yes, that is one of the best parts of our system, is that once the jurors are in deliberation, there isn't a person from the President of the United States to Chairman of the Joint Chiefs of Staff or anybody else who can come in and interfere with their deliberations until they've made a just decision in a case.
And as a matter of fact, it's very, very difficult, nearly impossible, to impeach the decision of a jury.
And that is as it should be.
So in this particular country, we have a unique power as citizens, as voters, and as jurors. Many of us think of it as a duty, and it is a duty, but much more than that, it's an empowerment, isn't it?
It is probably the single most empowering thing that a citizen can do. And what I mean by that is a lot of people have a dread when they get that summons in the mail. They're thinking, I don't have time for this. This isn't what I want to be doing. But what we see in reality is when they go through the experience, when they've been on a jury, when they understand the power that they have in deciding what sort of behavior is going to be acceptable in their community and what sort of behavior is not, what they will stand for and what they won't stand for. This is very empowering to people, and for the most part, they enjoy their experience immensely.
Now, that isn't to minimize the fact that it's a sacrifice, because jurors aren't really paid very much.
Not enough at all.
Yet, if we do not have the common citizens' access to the ballot box and the jury box, what happens to the justice system in this country?
Well, what happens is that a lot of the things which most people complain about in the political process, the influence of a lot of money and in our political system. I mean, we just went through a gubernatorial election where there was just an unreal amount of money which is being spent to influence perhaps decision makers going forward. We don't have that problem, but because it is so pure, we have to fight to maintain it.
And when we get down to the actual selection of a jury, as you indicated, the attorneys don't really select a jury. The jurors are selected, and in a civil case, we get to strike 3 jurors in most instances without cause. In a criminal case, perhaps we get an additional strike without cause. On what basis do we use our strikes?
Well, there are the strikes for cause, which are the ones where the person, either by their own acknowledgement or by the decision of the judge, probably is a little bit too close to an issue in the case to be fair. But certainly there is a right called the peremptory challenge in Wisconsin, where we have the right to decide that for whatever reason, even if they aren't clearly biased, that it doesn't seem like that person might be the best fit for the case. And so under that circumstance, we can deselect some people, and both sides can, in such a way to get a very much a middle-of-the-road jury for the particular action.
And then sometimes we have an extra juror or 2 if it's going to be a longer case because somebody might get sick or some tragedy happened in their family and they can't finish it, and it's awfully expensive to retry the case. So in that case, when the case has been completely submitted to the jury, how do we eliminate the extra juror?
Well, sometimes it's typically by lot, unfortunately for them. Their number is drawn in the same way that their number is drawn to be questioned initially and be selected as a juror. So unfortunately, those folks have given the sacrifice and they don't get to make the decision ultimately, unless and until there's a decision that one of the current serving jurors can't complete his or her job.
So the jury really decides the facts, the judge decides the law, and the jury reflects community values. And that way we have a system of fairness that is applicable to every citizen.
Absolutely. The jurors, it has been said time and again by the courts of this country, from the Supreme Court of the United States all the way down, is that the jurors are truly the conscience of their community. They get to decide what is going to be acceptable and what isn't, and what is going to be fair, and how we treat our own in our communities.
So Chris, you'd agree with me, don't give up the jury system and don't pass up the opportunity to be a juror.
I couldn't agree with you more. And in fact, we need more people who have a breadth of experience, and people who might be tempted not to want to serve or to find some excuse not to. In reality, they are going to be able to influence their communities more in that service than they can through almost anything else they can do.
Our time is up. Thanks for your input.
Thank you.
We'll be right back.
sure are a lot of us. Do you ever feel like you just don't have a voice?
What are you talking about? Send an email to your state legislator.
Huh? Who's that?
That guy right there.
Hey, what's up? Your state and federal legislators are your voice in our government. They don't speak for themselves, they speak for you. That's why it's crucial for you to be involved with who represents you. In last year's election, only 62% of these birds even registered to vote. And of that 62% who registered, only 2/3 of them bothered to vote. That means only 2 out of 5 are using their voice. What a shame. And voting isn't the only way to get involved. You can pay attention to what goes on in government and call, write, or visit your state and federal representatives. You can also join special interest groups with other like-minded citizens to let your representatives know how you feel. There are so many ways to get involved, and you definitely have a voice. Now go out there and use it.
Welcome back to the People's Law School, brought to you by the Wisconsin Association for Justice. We have another prominent Wisconsin attorney who is a member of the Association for Justice, and he's been trying lawsuits all over the state of Wisconsin. Jeff, welcome to the show.
Thanks for the invitation, George. Appreciate it.
What kind of work do you do?
Well, I do personal injury work. I represent people who are injured in auto accidents, but primarily I also represent residents who have been injured or killed as a result of abuse or neglect at nursing homes.
And a greater segment of our population is spending years in the nursing home these days.
Absolutely. You know, the boomers are getting older, and the fastest growing age demographic is over age 85. And they're getting older, but they're also sicker, and so they need the care that they can't get at home.
I would guess that representing the elderly people, the infirm people, people who are in nursing homes, presents some real challenges in terms of evidence, because often the victims aren't in a position to cogently testify. This might give us an opportunity to just talk about evidence. Evidence is what you present to the jury in a trial in order to persuade the jury that something has been done wrong and your particular client is entitled to damages. Why don't you tell us some of the evidentiary challenges that you have to face in presenting a case to a jury?
Absolutely. Well, first of all, most people don't realize that the jury really is the finder of fact. Not the judge, not the lawyers. It's the jury that makes the decisions as far as what are the facts of the case and then what verdict to render. So in order to be able to prove things, we have to have witnesses who come and testify, like they're sworn to tell the truth, the whole truth, and nothing but the truth. We have documents, especially in nursing home cases. The medical records are key documents about what happened in incident reports and in incident records. And then we also have medical illustrations, things like that, to be able to help demonstrate to a jury what happened to the person who was harmed.
Now, in terms of medical records, for example, they're pretty complex and difficult for most lay people to understand. How do you present that to a jury?
Well, we present them in several ways. First of all, we are going to have a nurse or a doctor is going to testify as to what is in those records. Somebody who will be able to distill it so that the average person can understand it. But what I find also important is that the jury get to see the record at the same time that the witness is testifying to it. So we'll actually have it blown up and then have it projected on a TV or onto a screen so that the jury can follow along with the witness and read exactly what the witness is reading.
Now, of course, where possible, you provide live witness testimony. Are there any particular challenges or difficulties in providing live witnesses to the jury as finder of fact in your kind of cases?
Well, there certainly are, because sometimes in my cases, the person who was injured may be deceased. And so it's also with staff at nursing homes, they may go from one place to the other. So number one, we have to locate them, find them, and make sure that we can get them under a subpoena to appear at trial if they're not cooperative. Okay. We also have to arrange to be able to have experts come to the trial, and they may or may not be from Wisconsin. And the same with family. We've got to make sure that the family is able to come to the trial and be able to testify about what they saw and about their experience and the relationship with their loved one.
Now, you've identified two different types of witnesses, expert witnesses and family or lay witnesses. Tell us how you use expert witnesses and why they're important in this kind of litigation.
Well, in a nursing home litigation or group homes, those types of cases, you have to have an expert who will testify as to what the standard of care is, what the rules were that the nursing home was supposed to follow, and how they didn't follow the rules. Because most people do not know what the standard of care is or the rules that apply to nursing homes, and so you need to have an expert, whether it's a nurse, a nursing home administrator, or a medical doctor, testify as to here's the rules that they were supposed to follow and what they didn't follow. Now, we also need experts to testify about what happened as it was caused by the neglect or the abuse at the nursing home.
So the damages also require an expert in most cases.
Absolutely, because it's usually beyond the expertise of the ordinary person to be able to identify when somebody fell, broke a hip, whether the hip was then the cause of that person's death, for example.
And an expert can give opinion testimony, but those of us who aren't experts as witnesses can pretty much talk about our observations without opinions. Is that a correct distinction?
That is correct. The average person can testify as to what they may have observed, whether they heard it, whether they saw it, whether they read it. That's what the ordinary person or the lay witness would testify at a trial.
Now, in a nursing home case, the family members that visited the victim, they can testify as to how he or she looked or talked or moved before the accident and then after the accident, and then it's up to the experts to point out that either the standard of care was violated or something else took place. Are there any legal limitations on the use of this testimony now?
Well, in Wisconsin, they did pass a law about a year and a half ago that makes it a little more difficult for the lay person, the ordinary person, to express opinions that may be considered into the area of an expert opinion. But the average person can still testify about the before and the after. And for example, in the nursing home case, friends and family can testify about how hard it was to find a nurse or to find a CNA, or when their loved one pressed the call light, that it took 30, 40, 50 minutes for somebody to actually show up. So that is very, very important testimony for family and friends to provide at a trial.
Well, Jeff Pittman, are our jurors attuned to what's happening to our elderly people in nursing homes today?
I think that they are attuned to some degree, but I think that there is great surprise as to what actually goes on, and the nursing homes and group homes decisions to put their profit over the care of their residents. And so even though I think they're concerned about the vulnerable elderly, they are surprised at the level of care that they should be receiving and they are not receiving.
So would you say if a loved one has had a real change in appearance or cognitive abilities, indicating that something may have happened, it's certainly worthwhile for the family members to seek legal advice to see if indeed some rights have been violated, injuries and damages to follow?
I agree with you 100%. If there's been a change in condition, if there's been a serious injury, or there's been a death, and they were concerned about the quality of the care, they should get an opinion to find out whether or not they can hold the nursing home accountable. And it's not just whether they can hold them accountable for their loved one, but it's so that they can prevent this from happening to another resident.
In short, see a lawyer that represents people, not insurance companies.
Exactly.
We'll be right back.
Hey, Bruce, we ought to eat these red bugs for lunch.
What, are you crazy? Those red bugs will go straight to your hips. Now, these blue bugs over here, these guys are delicious. Let's eat them for lunch.
No way. Blue bugs will kill you. High in the sodium. You're nuts, Bruce. We're eating the red bugs.
Blue bugs.
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 Red bugs.
Blue
Red
bugs.
bugs. Red, red,
Blue
red, red,
bugs.
red, 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 red.
Just as Pinky and Bruce had a hard time agreeing on what to eat, people disagree about the laws they want to pass and which policies to adopt. The arguments that legislators have with each other in Congress and state legislatures are reflections of the disagreements among we, the people.
Welcome back to the People's Law School, brought to you by the Wisconsin Association for Justice. The Wisconsin Association for Justice is a group of trial attorneys who largely represent injured people, usually against insurance companies attempting to get compensation and damages. We've got another trial lawyer with us, and he's a member of the board of directors of the Association for Justice, and his name is Heath Stracco. Welcome to the show.
Thank you.
What kind of litigation do you work with mostly, Heath?
Well, I generally represent injured people, and that can be whether they've been injured in an auto accident as a result of some sort of mishap in a hospital or at their job. And that is, we represent people who may not have been paid fairly in a wage and hour context as well.
Now, many people have a perception of a trial because they've watched television. And unfortunately, for them, and sometimes for us, that isn't always how a trial really works. I'd like you to help our viewers a little bit with the anatomy of a trial. We talk a little bit beginning with the selection of a jury, and Chris Stambo helped us with that. After the jury has been seated, what happens next?
Well, you started by saying how different it is in real life from TV, and it's true. What people see on TV is vastly different from what we actually do from day to day in trials. After the jury has selected and has been seated and has been able to call their loved ones to say, I'm going to be in trial for the next 7 days, and we need to make arrangements to pick up the kids, the first thing that they really see is some opening statements, not arguments, but opening statements by the lawyers to give them an idea of what the case is going to be about and what they're going to hear about for the next few days.
What goes into an opening statement?
Well, what you want to do in an opening statement, you want to be concise. You don't want to bore the jurors, and you want to tell them what they're going to hear from witnesses, what they're going to see in terms of visual evidence over the next several days, and what that person's burden might be in terms of proving that type of case.
Any warning about saying things that you're not sure you can prove?
You hit the nail on the head. You have to be very careful not to overstep during opening statements, because if you don't come through with that promise, the jury's going to hear about it in spades during closing arguments at the end of the trial, and you're not going to look very good.
So both sides get to give their opening statements to give a kind of a roadmap, it's often referred to tell the jury what to look for. And then what happens?
Then what happens is, after each side has given their opening statement, the live witnesses start. So the judge will ask usually me or the other plaintiff's lawyer who's representing the person who's been injured, and please call your first witness. And that person comes from the back of the courtroom and stands in front of the clerk and gets sworn in, and a question and answer session starts.
Why does the plaintiff go first?
Because the plaintiff has the burden. So if for people who maybe have been in debate back in middle school or in high school, the person who is trying to get a yes to a certain question gets to go first, and they, at the end, get to go last as well, because they have to make sure that the jury agrees with them to get that yes answer on the verdict.
Now, you're a plaintiff's lawyer. I try to be a plaintiff's lawyer myself. In other words, when we have presented all of our evidence and our argument, the juror still isn't fully convinced of our side being right, feels very strongly both ways, we lose, don't we?
Correct. We have to, in a sense, tip the scales in our favor. And it can be, what I like to tell a jury is, we have to prove something more likely than not. You don't have to prove in a civil case something beyond a reasonable doubt. That type of burden is left for the criminal type cases, and rightly so. In a civil type action, which is what we do, the burden is a more likely than not burden, and whether you can tip that scale slightly in your favor or not.
So we put on